murder cases, and Justice Lowy issued a detailed decision about the issues in these types of cases. The court found that a defendant charged with first-degree murder has no right to bail, but may be admitted to bail in the discretion of the judge. The court ruled that a judge should consider the nature and circumstances of the offense and weigh the defendant's risk of flight in light of the strength or weaknesses of the Commonwealth's case and the potential penalty of a sentence to life in prison. The court further noted that appropriate considerations for a judge would include the defendant's family ties, financial resources, length of residence in the community, character, mental condition, record of conviction, appearances at court proceedings, or any previous flight to avoid prosecution or failure to appear at any court proceeding. It is important to note that the purpose of bail is not to impose punishment. The court has conducted a careful review of the details of the case and the defendant's history. The court's reviewed the filings that have been made, as well as letters submitted by counsel for the defendant and the update that was received from her attending trauma surgeon. The factual allegations in this case are both horrific and tragic. The potential penalty faced by the defendant, if convicted, is severe. The defendant has no criminal history. She does not even have a driving record. There is no evidence of any history of any abusive behavior by the defendant. The defendant was raised in New England and has extensive ties to the local area. She has an extremely supportive family. She had worked for several years in a local hospital, and a number of co-workers have written letters in support of the defendant and her character. She's described in these letters as an exemplary worker, colleague, and friend. In the letter submitted by her attending trauma surgeon, she has extensive injuries that will require long-term inpatient rehabilitation. Weighing what the doctor has written and the facts in the defendant's current condition, the court finds that there is minimal risk of flight given the defendant's circumstances. The court is going to make the following order on bail. The defendant shall remain in her current hospital until medically cleared to be moved to a new facility. As a condition of bail, the defendant is ordered not to leave the hospital until discharged to a new facility. The defendant shall provide notice to probation 48 hours in advance of any transfer to a different facility. Based on the letter of the doctor, it would appear likely that she would be sent from the hospital setting to a 24/7 rehabilitation facility, like the Spalding Rehab. As a condition of bail, if sent to a 24/7 rehabilitation facility, she is ordered to remain in that facility, with the exception of if she needed to be transported to a different medical facility or a hospital for an additional MRI or something like that. The defendant shall continue to receive mental health treatment while hospitalized and sign releases for probation to monitor compliance with counseling. In the event that the defendant were to complete the services at a 24/7 rehab and complete that care, the court would hold a further hearing as to whether or not the defendant were in need of further mental health treatment that would need to be done in an inpatient setting, or whether or not the defendant's mental health care could be provided in a residential setting. The court would direct the court clinician, court doctor, to consult with the defendant's mental health providers to conduct this evaluation at the appropriate time in the future. If the defendant were in a position that she was going to be discharged to a residential setting, both sides would have the opportunity to be heard further. Any discharge in a residential setting, the defendant would be subject to home confinement with appropriate electronic monitoring to monitor home detention. There would be exclusions that would be available if the defendant needed to attend medical or rehabilitation appointments, counseling sessions, or religious worship sessions. The court would have probation visit any proposed residential setting prior to the defendant being discharged to that type of a setting to ensure that such setting was appropriate and safe. The defendant is ordered to surrender her passport to probation. In the event that the defendant does not have a passport, she is prohibited from applying for a passport. The court is not going to set any monetary bail at this time.
Your Honor, would the court order that any such residential setting be in Massachusetts? I don't think we could do monitoring outside of the state.
If we get to that point, you may make that request. If it becomes an issue, we can deal with that. We clearly have the ability in Massachusetts to appropriately monitor. If for some reason, I know that there are relatives that live in Connecticut, if something like that were being requested, obviously the court would need to make sure that appropriate monitoring were in place, but both sides would have an opportunity to be heard regarding that request. The next step in this matter would be to schedule a probable cause hearing. Is there a date that the parties would like to suggest for that purpose?
About May 2nd, Your Honor. It's going to take some time to...
That is fine.
Thank you.
Obviously, I would believe that it would be highly probable that the Commonwealth would be proceeding by way of indictment to the grand jury. In the event that the defendant is indicted, counsel for the Commonwealth will notify Attorney Reddington and make appropriate scheduling for arraignment in Superior Court.
Very good.
There was a matter that I'm not sure if the parties need to address. There was an impoundment order as to a document that was signed by a previous judge. Do either of you wish to be heard on that?
I think by agreement at this point, we'd ask that all impoundment orders be extended and that defense counsel be allowed access to copies of the documents.
It appears that Judge Sullivan had issued an order specifically as to one document, and that order will remain in effect. It may be readdressed at the next court hearing.
We're not anything filed today.
As far as what is in the, as it would relate to the doctor's report or any of the letters.
I don't have any request to impound the documents filed today, Judge.
Okay. That's fine. And obviously the documents submitted by the Commonwealth would become part of the court file, as would be the application of complaint and documents that were attached to and submitted in support of the complaint.
Those are now, those will be released.
Yeah.
Okay.
Your Honor, we have signatures and
Yep.
probation execute signatures to counsel.
Yes. Counsel for the defendant may sign the conditions of probation The conditions of probation have been read to the defendant, and they're clear. If there's any issues, they can be addressed on a further court date, but those will be the conditions that the defendant is subject to, and counsel can sign on her behalf.